Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, everyone. Hi, couch potatoes. I missed you so much. I'm so happy to be here today with you guys, and in a better mindset and feeling department over here. But I hope you all had a lovely weekend. It's been a while, hasn't it? But we're here on a Monday, which is already starting out to be the Mondiest of Mondays. So you'll have that. You'll have that, but you know what? That's fine. We have each other because we're besties. And sorry, yes, I was a few minutes late because I needed coffee. I needed coffee like real bad. So sorry you had to wait for me. Hello, Lady in Gray. Hello. Good morning to you. Deanna, good morning. Happy to see you. Violet, hello and good morning. Terry True Crime, good morning. Winks, good morning, babes. Carmen, not Electra. Oh, thank you. Thank you. Happy to see you here today. Dan Montana, you're going to be lurking. That's fine. We love our lurkers too. We love our lurkers too. No, thank you all for all of your kind words. This last week, after we've been mourning the loss of my sister-in-law, suddenly, it was a hard week, you guys. It was real hard. But thank you all for your kind words. For those that donated to the GoFundMe, I mean, I can't even tell you how appreciated that is. Saturday, we went to my sister-in-law's oldest son's graduation party. Yeah, it was kind of fucked, the timing of everything. But actually, it was really nice. It was a lovely party. It was, graduation party, but also a wake as well. And so just being surrounded by all the family just was really therapeutic for Elbow Feet and I. And it just feels like, okay, it's okay to start moving forward, I guess. So it was a lovely day. Considering the circumstances. But thank you guys for that so much. I can't even tell you how much it means to all of us in the family and the boys. I miss your face, Terry. I know. They'll tell you. I haven't really been talking to anyone in the last week. So thank you. Thank you. So because I took a whole week off, we got so much to fit in a really short period of time regarding everyone getting caught up on Mike Marraccini. Because you guys, in less than 6 days, 5 days, if you want to include today, we're doing our 12-hour Mega-Stream Fundraiser for Mike Marraccini. You guys are going to get so much of me this week. You're going to be like, all right, Llama, too much of you. I'm just kidding. Oh, sorry, I got to get comfortable here. Hold on. Okay. But so we're going to be doing that on Saturday. I'm so excited. Going to do a bunch of planning today. Oh, I can't believe we're going to do it. I think it's going to be amazing. So hello, Teresia. Hello. And no thanks. Okay, thank you. So happy to see you guys here. You guys are so kind. Buffy, one of my besties, is in the chat today. She might join us a time or two this week. We'll see. Echoes. Hi. Hope you're doing well. Thank you for your message. By the way, I will respond to everyone's kind words on that you all left on YouTube for me. I haven't really been able to, but all of your guys' kind words were just so great. Echoes is one of those that's going to be at the fundraiser on Saturday, which I'll be letting you know soon when it's going to be, when you show up. For everybody else, it's from 12 p.m. to 12 a.m. Eastern. Lots of familiar faces, some non-familiar faces. I'm so excited to talk to everybody. We're going to be auctioning off all sorts of items throughout the day, trying to raise a lot of money for Mike. As we know, Laura is still trying to appeal the DVRO that she couldn't be bothered to show up with, which is a very expensive fight. It's ridiculous that she's doing it in the first place, but to the surprise of no one, because it's Laura. Um, so we're helping raise money for that and his family, and it's going to be such a fun time. So I got to make sure to. It's the only time you will ever see my name next to the word marathon. I can tell you that because I don't run them. So this is the closest you'll ever be seeing that for sure. Hello, Jupiter. Hi, hope you're doing well, babes. Henrietta, good morning. So happy to see you here. Bruce the Moose, ahoy, good sir. Hope you're doing well. So happy to see you here as well. Oh my gosh, they just keep going. Oh, I miss y'all so much. It's so nice to say hi to you guys. Just wanted you to know that. I am just as happy to see you as you are to see me. I promise. Hello, Lainey. Speaking of Lainey, you're doing a show in Dallas, Texas on Saturday, and you're going to meet Terry True Crime. I'm so excited and jealous, by the way. That's true. Bruce will be on the fundraiser as well. Oh, I'm so excited. I am so excited for all of you guys. So we have been trying to catch up. We paused on Owens versus Eckerd, and we're catching up to modern day times in the timeline regarding Mike Marraccini in 2025 to 2026. So we will get through all of that. Now, we're not going through every single thing that happened because we're going to cover what's important for the fundraiser. And then we'll go back to Eckerd, and then we'll cover everything we didn't cover with Mike Marraccini when we get to that in the timeline months later. So I just wanted us all to be pumped up for this weekend because I'm going to have like a whole table of drinks, snacks. It's going to be a great time. So I'll be here till about probably 1 today, and then the lovely Terry True Crime does Midday Missing. I do have like a 5-minute doctor phone call that's going to come in at some time, but when I do, I'll just put on some memes for you guys, and I'll be right back. But it won't be very long, and don't worry, it's not like it's something important or anything like that. I was just like, well, okay. So I'll be here every day this week at 10 a.m. Eastern, and then Wednesday I'll do in the afternoon at like 2. We'll have an afternoon show because I can't really do the mornings because I think Terry and I have coffee with Terry and Llama for our bestie members in hire on Wednesday. I forgot all about that till just now. Oh, thank you, Winks, for gifting 50 memberships. You are so nice. Oh, thank you so much. Congrats to all the new members. If you don't have your gifts turned on, you should. We have a very generous community, obviously. I think you just go to the join button, and I think there's 3 dots on the right-hand side, and you click that, and you'll see like gifts, allow gifts or something like that. So oh, good. Lady and Grace, drop in the command because I forget every time. There you go. Do what it says on the screen. I'll leave that up there for a few minutes. But thank you, Winks. You are so sweet. So today, what we're covering. So where do we leave off last Friday? Does anybody know? Because I should have looked before. I think that I know. Laura was not wanting there to be any live testimony at all. She wanted a direct judgment and no live testimony because there was nothing that could be argued about for this renewal of protect. Excuse me. Oh, did you guys miss my burps? My random burps. Where was I? So she. I'm trying to remember. Sorry. This is a quiz for myself, really. Okay. So she didn't want live testimony because she was like, oh, nobody has a good argument for anything. They're not going to argue that, Mike was at the trial for Owens v. Eckerd. Mind you, he was there because he was subpoenaed Okay. But she didn't like that. And so she's saying, well, he is such a threat to me. He's so scary because he flew from California to Arizona to go to this trial I was at. And that's enough. I need a permanent one for the rest of our lives because that was just too much. He knew what he was doing. And they're like, it's undisputable that he was there. So if people have something that they want to say, they can just put it in writing. And we don't need to take this to a trial, just have them put it in writing and that'll be enough, which is crazy, quite frankly. You would even request such a thing. Basically, because she didn't want to get on the stand ever, because she is a liar. Because remember, too, during this 2025, she has gotten the first 7 felony charges for Clayton. So, girl's not going to look good on the stand. No, no, no. Oh, thank you. No thanks, MK, for becoming a YouTube member. Thank you so much. We have tons of member only content over on our members tab, all sorts of different shows we do. So please enjoy it. I know that they watched The Crash last week and came on and talked about it, but I didn't get to watch it yet. So I'll probably be doing that this week. And hello, Shanta. Hello. Hope you're doing well today. Pam, I don't know if I said hi to you or not, but I'm going to say hi to you again. Hello, Pam. Hope you're doing well. Out on top, the burp queen. Yes, I'll take it. It's fine. At least I'm the queen of something. Oh, you don't want you didn't want to miss the fun. Oh, I love that. Hello, Say Cheese. Good morning. I hope you're doing well. All right, so we got quite a bit to read today. Where did I put all my stuff? I'll tell you what, even when you're gone in just a week, it's like kind of forget how to do some things. You're like, oh yeah, that's right. I'm a little slow. I gotta work it, figure it out. You're about to have a big day. All right. So we are in August. Oh wait, that's not how I do that. All right. Okay, I don't know what that was about glitching out, but okay. Okay. So this is from Mike and Omar's side, because Omar's his lawyer at the time. And this is in opposition to Laura's motion to proceed by declaration and waive life testimony pursuant to these codes. Now, we're not going to read the first 4 pages because it's basically a recap of what happens, has happened. And the next one that we're going to read today, it recaps it all. So we'll just save that for later. But I basically caught you up. So she's taking Mike over to court over bullshit is really all you need to know about any of these things. I also, on Saturday at the party, I was like trying to tell people to like go listen to Love Trap, come watch my stuff because they don't know what I do. I mean, they know what I do, but they don't know what I do. They're like, what do you mean people on the internet listen to you? And I'm like, I don't know. No, they're not. They're very supportive, but they don't know what I do. But I was like trying to explain to them Laura Owens, and literally after every sentence is just me either saying it gets so much worse or like whatever you think is the line is not the line. It goes further. So hopefully they will start listening because I was like, no, this is crazy. Everybody's got to know about this. Hello, Savage. Happy memberversary. Good morning to you and the rest of you filthy animals. I added that part. Oh yeah, for our members, I have a whole other show called Llama Learns About where we learn about very weird things, and it's always a good time. Sometimes you don't know how weird things are until you're like, oh, mistletoe? How innocent is mistletoe? Turns out not that innocent. It's a sperm plant. Just to let you know. But all right, so we're going to read this first. This is in opposition to the declaration and waive live testimonies. So let's go over here and we'll work on reading things. This case is an onion. So many layers. I know. That's what I kept saying over. And I was like, I'm still only telling you like the tippy top of the iceberg. And I was like, I know that reading documents, court documents sounds boring, but it's not. Not a single one. I mean, can they be? Yes, they can be very boring. None of these have been that boring at all. So it's a sex plant. Oh, wait, there we go. It's a sex plant, that dirty, dirty mistletoe. You've made it 9 months without being permabanned. We would never. We would never. You were there for the James choice. That's true. If you did just become a member, go to our members page. The last Llama Learns I did, Elbow Feet came on. It read the erotic letters that author James Joyce wrote to his future wife, Nora. And they are, people have always been kinky, is all I'll say about that. It's a lot of elbow feet reading very seductively, and me just read the whole time. So enjoy that. All right, let's get into this today. Whatever I don't finish today, I'll tack on to tomorrow. So, but we have quite a bit to get through these documents here. All right, so remember, this is Mike and Omar arguing about why no, we're doing live testimony, and no, don't just dismiss this case, or I'm sorry, put a judgment on this case, because we got things to say. So, all right, so Owens' bid to avoid live testimony is an affront to fundamental due process and a disgraceful ploy. Oh, look at him already starting off spicy, Omar. Oh. And a disgraceful ploy to shield her chronic falsehoods from cross-examination. Owens' current felony defendant of 7 felony counts, let's all say them together: perjury, forgery, evidence tampering, among others. For conduct that involves the underlying facts of this case, now asks this court to proceed with her criminal behavior without the scrutiny of live testimony. I mean, having those charges when you're on the stand, any defense attorney is like wet dream right there. Like, oh, you've been charged with perjury. Wait till she's found guilty. I mean, I know, or pleads guilty. I know that there's been talks that maybe she'll do a brand new DVRO against Mike, because why not? That's what she does. But the minute she has those felonies, oof, it's going to be hard for her in court. So can't wait. That's for sure. All right, the court should categorically reject this maneuver. Now, California Family Code mandates that live in-person testimony be received at hearings absent a stipulation or a compelling showing of good cause. This is a substantive DVRO matter involving a restraining order where there has never been a finding of domestic violence, regarding material facts hotly in dispute, where Owens' credibility lies at the very heart of the case. Every factor enumerated in Rule 5.113 demands live testimony. Laura's motion attempts to evade cross-examination and continue her criminal pattern of deceit. Ooh, I like those words, Omar. Her criminal pattern of deceit without judicial scrutiny, hoping her written narrative will escape the crucible of truth testing. And that's exactly what she wants. She just wants to be able to write about all of her feels and not be caught off guard, like she was in Owens v. Eckert, which got her some felony charges. So I can see why they're like, I don't want to go on the stand. And everybody's like, no, girl, you got us here. You're going up there, right? Hello, Dawn. Hello. Thank you. Thank you. So happy to have you here. So happy to have you here. She says, I love listening to Omar's writing. He's very polite, but biting. Well, we just got into it, and I agree so far. Now, Owens' documented history of perjury and forged evidence invalidates her pleadings. Her claims must be tested under cross examination. The court should deny Laura's motion requiring her hearing on renewal to proceed as an evidentiary hearing with live testimony. In addition, respondent Michael Marraccini requests that the court impose appropriate sanctions for Owens' abuse of process and refer this matter to the district attorney for investigation of potential criminal conduct, including witness intimidation and offering false evidence again. Oh, I did not know that. I did not know that Omar wrote that. Because remember, Mike's in California, right? So they're like, hey, maybe your honor, should look this over and then send it to the district attorney's way, because that's what happened in Arizona. And this is very similar to that case. Oh, because I know some of you have mentioned the possibility of her catching charges in California. I did not know that it was suggested by Omar originally. So, oh, okay. All right. Interesting. There are no current charges in California yet. Yet. So we'll see. My little dog's streaming. She's so funny. She sounds like a squeaky toy. And goes, broop, 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 broop. That's exactly what it sounds like. She's so funny. All right. So, under California law, live witness testimony is the rule, not the exception, at family law hearings involving restraining orders. So, this Family Code 217 provides that at a hearing on any order to show cause or notice of motion under the Family Code, absent the party's stipulation or a finding of good cause, the court shall receive any live competent testimony that is relevant and within the scope of the hearing. So, yeah, there's really no reason for us not to have live testimony here at all. And it can also, too, I mean, maybe this was an argument like before the internet, but now you can just do Zoom. So there's no reason to throw out live testimony, I don't think. Henrietta sure hopes she catches them, right? Like her little felony Pokemon cards she's collecting over there. Me too. Me too, Henrietta. She says she could also be charged for the fake Chase J. Jones opposition to subpoena if that ever got referred and if LA cared. Well, LA probably doesn't care because their courts are busy. But you're right. That's true. I forgot about Chase J. Jones and that she sent that to court. I'll tell you what, the line this woman, like, could you imagine? None of us would be like, you know what I'm going to do? Fake being a black guy and send in this motion to quash a subpoena to a court and be like, yep, I'm going to do that and nobody will know. It's totally fine and I'll get away with it. That's crazy. Oh my gosh. Anyway, so California, this part's going to be a little legalese, but that's fine. California rules of court implements 217 by enumerating factors a court shall consider before denying live testimony. These factors include whether material facts are in controversy and whether live testimony is necessary for the court to assess the credibility of the parties or other witnesses. Each of those factors decisively favors live testimony here. I guess another thing, could they be talking about like depositions too? Right? Is that what that applies to as well as like, oh, well, because those aren't live testimony, or are they considered live testimony? Because lawyers are always all there. I've seen some criminal cases where they've done that. Who was it? That Jensen guy in Wisconsin. Oh, that guy. Mark Jensen, I think it was his name. But he had like a retrial. So they had to use recorded testimony from the first trial because a few people had like died or something in between, like investigators. It's very weird and interesting. But they just played it, and that was like it. So um she is like Sarah Boone and Sharilla. Reality be damned. We just make it our own now. Hi, Jill. Oh, thank you. Thank you. Thanks for being here today. I appreciate that. I am so happy to be back. I'll tell you that. I mean, I don't get to watch as much Real Housewives of Atlanta, but what are you going to do? Those ladies got me through this week. I'll tell you that. You only need like 3 brain cells to watch it. So I was like, I got that many right now. All right, so this is a contested DVRO renewal involving diametrically opposed accounts of past events where virtually all material facts are in dispute, all of them. More importantly, credibility is paramount, especially with Laura Owens around. Owens' case rests on her claims of fear and past abuse. This renewal hinges on whose narrative to believe. The California Evidence Code explicitly recognizes that in determining a witness's credibility, the fact finder may consider any matter that has any tendency and reason to prove or disprove the truthfulness of their testimony, including the witness's demeanor, character for honesty, which is like 0, and prior inconsistent statements. These credibility factors cannot be meaningfully evaluated on the cold paper record. A declarant's written words reveal nothing of her tone, hesitation, or eye contact, and they prevent the opposing party from probing inconsistencies in real time. They're like, you should see how she is on the stand, Your Honor. You need to witness this with your own eyes. Please and thank you. Okay. So to assess the credibility of Owens, whose honesty is very much in question, the court must observe her live under oath and under cross-examination. California courts have consistently emphasized the importance of live testimony in contested matters, particularly in cases involving restraining orders or other significant issues where credibility and due process are at stake. The courts have condemned decisions based solely on written declarations without providing parties the opportunity to present live testimony, cross-examine witnesses, or otherwise fully participate in the proceedings. I mean, I don't see why there just wouldn't be live testimony. I'd like to know some examples of when that's happened and why. I'm sure there's maybe a few good ones, but it seems weird. But okay. Let's see. Sorry. Let's see here. Whose honesty is non-existent. Her honesty is about as real as all those twin babies that miraculously disappear and reappear and disappear again. Basically, magician fetuses is what she has. All right. So the appellate court in Marriage of DS and AS emphasized that both family code governing DVRO issuance and due process principles required a proper evidentiary hearing with witness testimony. Now here, Owens wants the court not only to consider issuing a permanent DVRO renewal against Marraccini, but she desires criminal prosecution without ever hearing directly from either party in court. Oh, I forgot about that. I forgot in her when she filed this, whatever it was called. I don't know. My brain's listen, I'm only at like 65%. Okay, my brain. So but I forgot that she say like he should have like federal charges against him for flying from California to Arizona because he was subpoenaed by the judge. Federal charges, she said. And I think she quoted some like federal law or something. It's like, girl, you need to worry about your own felonies. Like, what are you doing? Like, oh, all right. And I mean, here her parents are filing for bankruptcy again. Oh, yes. I don't remember if I ever got to talk about that. I don't remember when that news broke. Maybe it was over the weekend. I don't know. But yes, the Owens parents are filing for bankruptcy again. And it seems like it's kind of a sketchy filing. I don't know. I've read it and seen it. Doesn't mean I was comprehending anything. And I know that Big Tiff went over it this weekend. I have that on my queue because when it's financial stuff, I listen to her because she knows how money works, and I don't know how money works. But the Jennifer G, who was in charge of Laura's bankruptcy hearing, is going to be in charge of her parents. Anyway, but just what I'm saying, Laura, is you might not want to just throw out federal charges into the universe like that. You might want to be careful. Because you remember, like in everybody else's cases that we've covered, she'll be like, they're breaking criminal code, blah, 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 and they should be charged for this and get felonies. She's always pointing out how other people should get criminal charges for their wrongdoing. And yet it was like the greatest universal foreshadowing. Like, okay. So funny. Hello, Stringer Bell. Good morning to you. No thanks, MK says she's the one crossing state lines to the light of the courts. Right? Right? And, at this time, I mean, she's in Arizona. He's in California somewhere. I don't know where. I know court takes place in San Francisco, but I don't think either of them are even residents there anymore. I don't know. But what do you need a permanent one for? This is really just to get back at the community, is my opinion, based on what we've read so far. Because remember, she went on JFC rants about how we're all in a cult. So Dawn, my brain is weird, but I just heard, Lieutenant Dan, you have magic fetuses. Lieutenant Dan, you ain't got no legs. A fetus is a magician, yes. Just think of all the magic tricks. Say Cheese says every accusation is an admission. Yes. I mean, I don't know if I've ever seen a case where it's like literally every single word that comes out of any of their mouths. It's like that. Wild. All right, where were we? Granting request. Okay. Respondent is Respondent is Mike. Okay, so Mike intends to testify and present evidence after being properly noticed and served to refute Owens' claims. He has a constitutional right to cross-examine Owens on the stand. Owens cannot unilaterally waive the presentation of live testimony when the other side demands it. In the absence of any stipulation, the court must take live testimony unless Owens shows specific good cause to refute it. And as explained below, there is compelling cause to require Owens to appear and testify. Well, we all know Laura's good cause is, I don't want to. I just don't want to. And that's enough. Because that's always it with her. Yeah, I don't like it, so I'm not going to do that. It's all the time. All right. Part 2, petitioner seeks to evade cross-examination as her claims cannot withstand scrutiny. Not only can her claims not withstand scrutiny, her entire being can't either. I'm surprised she's not like, does she? She probably does somewhere in here type. Omar Zerrato is just trying to embarrass and harass me in the courtroom. Don't let him do that. Probably. She's blamed everybody else for doing that. You're just trying to embarrass me. Ugh. I'll tell you what, I'm so happy to be back talking shit about Laura Owens. That'll get your your mood back up when you can just be like, you know what? Let's just talk shit about Laura. That'll make me feel better. Hi, Minnie. Yes, thank you so much for your kind words. Yeah, I'm happy to be back too. So you're so sweet. Thank you. Dawn, she's such a petty Betty. She is a petty Betty. Sorry, Betty's out there, but she's a petty Betty. Lady in Gray says her appeal is nothing but spite. I agree. Not spite just against Mike because he holds, her story, entire identity is on him. Clearly, she lost everything in the Clayton storyline there, even though we have to go back and watch it all. But then she is pissed at the internet, and so she's just taking it on him. And this is before she gets 7 charges for Greg. So this is just another reason why I do not believe she is just going to let Mike go at all about anything, because it's her entire identity. And she doesn't want to lose face on the internet because she cares way too much about what other people think. It'd be nice if she listened, took some of our advice, but no, it's cathartic. Yes, it is, Demontia. It is. It is. They say that it's easier to bond with people when you guys don't like the same person or persons. By the way, there's a study about that somewhere that I read once. I thought that was very interesting. All right. So Owens knows her narrative will collapse under cross-examination. Owens' goal is not convenience or efficiency. It is concealment. Ooh, nice. That's a great sentence, Omar. First, Laura's professed reasons for avoiding live testimony, to the extent she articulates any in her motion, do not hold water. Owens claims she feels traumatized or fearful of being in the same room as Mike. After obtaining the DVRO in 2018, Owens actively sought out contact with Marraccini, messaging him repeatedly, approaching his family, even traveling across the country to confront his employer with her allegations. What? I don't think we learned about that. That wasn't brought up in the other ones. What do you mean? Oh, I need more about that. In September of 2024, wow, oh, he's going to tell us. Okay, thanks. Thanks, Omar. In September of 2024, while on a trip to New York, Owens made an impromptu stop at Marraccini's employer's HR department to alert his employer that he had a DVRO issued against him. What? Why would you do that? What? This bitch. I'll tell you what. I've got a whole this bitch list. I mean, she's at the top. Some other people have now made this bitch list. But what? Why? Why would you? Oh, she is so spiteful and awful. Dawn says she just, or the whole world is out to get her. I mean, like they say, if everyone thinks you're an asshole, you probably are the asshole. She's definitely the asshole. The enemy of my enemy is my friend. That's true. That is true. Literally speaking to his manager. Yikes. Oh my gosh. Does anyone know, was she granted her motion for more time on her appeal against Mike? I believe it's due at the end of the month, like the 29th or something like that. I don't know. A lot of stuff is like left my brain, but I feel like, or maybe it's the end of July 20th. It's sometime soon. She has to have it in. So, oh wait, did Say Cheese give us she got an extension for the filing, but I'll check to see if anything else has been done. I haven't gotten any auto updates for the court. Thank you, Say Cheese. Appreciate it. ILTA. Yes, she is. No, she is the asshole. No need to ask Reddit. Nope, no need. Wow, I can't believe she did that. I hope he didn't lose his job. Actually, I'm going to write that down on my list of questions. I don't know. Show notes. Sorry. If I don't write this down now, I will completely forget about it. Let's go down. Laura. That's crazy. Okay, well, that's a mess. I had my caps on, but whatever. I'll fix it later. Which page was I on? Okay. So she gave a public TED Talks in January 2022, describing herself as a domestic violence survivor and recounting her accusations against Marraccini. She authored a Chicken Soup for the Soul essay in June 2023, doing the same. In none of these very public forums did Owens exhibit the slightest hesitation about reliving her claims. Yet now, when it comes time to actually substantiate her accusations under oath, Owens suddenly shrinks back and pleads to do it on paper. I love that he's calling her out for that. Exactly, Omar. Exactly. Her newfound reluctance is not about emotional difficulty. It is about avoiding the exposure of lies. Lobster claws. Excellent. Excellent. Good job. Good job. He doesn't need me to say good job. He's like, yeah, thanks, Llama. I know. I'm a fucking lawyer. Well, good job, Omar. That's exactly it. She can talk about it all the time, all she wants. But then when it comes to time, no, I don't want to. I'll tell Reddit, but then I'll be mad at them afterwards. Oh, she's such a cloud chaser. Right? You're an asshole. I love that song. Oh, Berkeley Farm. You know what? I think I skipped you, Berkeley Farm. There you are. Hi. Hello. So happy to have you here, Berkeley Farm. Clout chaser indeed. All right. Second, Laura's procedural conduct shows a desire to ambush and silence Marraccini rather than a bona fide need for accommodation. Oh, that's right. I forgot so much. There is the whole I have a disability and you guys need to like cater to me because she has autism now at this point, which, okay, for somebody who loves going to court about shit, then when it comes down to it, she's like, oh no, I can't do that. Oh, she's the worst. Oh, virtual juror. Hi. Good morning to you. You guys, virtual juror, I still have to finish your video. I got through quite a bit of it, but then I got a phone call and was distracted. But virtual juror just had a video drop this weekend that was putting together more of a timeline. She started with the Sweetums, right? Is that it? The sweet? I was getting confused with Park and Rec. Sweetnums, the horse saga that we barely touched on. So I definitely recommend going to watch her latest video about that because I learned lots of new stuff because we did not get into it. And then she went into Mike's case. She was doing this really excellent timeline stuff with traffic tickets. That was interesting. Anyway, she's doing a great job over there. So go watch her video after this. Plus, she's going to be on our fundraiser. What time yet? I don't know. I'm going to do scheduling today to let everybody know. But I am very excited to talk to you about what you've been up to and what you're doing. I thought it was very impressive, for sure. Oh, thank you. Yes, started 2014 to 2019. Oh, then I didn't miss much then. Oh, that means I should only have like 15 or 20 minutes left. Sorry, I'm just used to me doing like 6 hours. And like, well, I guess I'll get to it one day. Yeah, but go subscribe to the virtual jar. Give her some love. She's kind of new to all of this. So yes, you're combining all the timelines together as things happen. And that is no easy feat, girl. We've done our best, but at one point we're just like, well, I guess we're gonna have to cover it all at once because can't keep this separate anymore. Crazy she thought that no one would know that horse. I know. Yes. Okay. Let's see here. Where was I? She hadn't even served marriage. Okay. We'll start the paragraph over. Anyway, I got distracted. Second, Laura's procedural conduct shows a desire to ambush and silence Marraccini rather than a bona fide need for accommodation. She hadn't even served Marraccini with the renewal request or this motion, presumably hoping he might not appear at the August 1st hearing, allowing her narrative to go unchallenged. Oh my, she would never do that. She absolutely would do that. In a declaration, she can say whatever she wants, blatant falsehoods without risk of immediate impeachment. Oh, look at him calling her out. Love it. Love to see it. In no regard, no regard, okay, the California Court of Appeal reaffirmed that denying a party the right to testify or offer evidence is reversible per se. The court emphasized that family law judges must ensure a full and fair opportunity for parties to present all competent, relevant, and material evidence. Litigants have a fundamental right to testify and call witnesses, subject to reasonable limitations such as excluding cumulative or unduly prejudiced evidence. Now, Owens' bid to avoid testifying is an attempted end run around the truth finding process established by basic due process. Right, Laura? Everybody gets to do this. You are not a special little dewdrop, okay? The last time Owens' claims were tested under cross examination, she perjured herself to such a degree that she is facing 33 years in prison in Arizona. I love that he underlined it because honestly, like, you don't see very many people getting perjury happens all of the time. All of the time. It does. That's just how it is. Everyone's like, oh, put my hand on the Bible. I swear, blah, blah, blah. Well, guess what? People fucking lie on the stand all of the time. But very few people get charged with it, right? Because there's also, like, you can think somebody's lying, but you also have to prove that they know that they're lying. There's like a few steps in between or something like that when it comes to getting a perjury charge. So I'm sure that when a judge reads that she is facing these perjury charges, then they're like, oh, she just done fucked up because they really don't charge. I mean, one, we also don't have the resources to be chasing it all down, but it hardly ever happens. So Omar should, Berkeley says, Omar should have said up to 33 years, but the point does stand. That's true. And he's just manifesting, though, Berkeley, just manifesting those 33 years into the universe. So far, it's not looking like she would get anything close to that. I mean, I'd be surprised if she even got like 5 years, to be quite honest with you. Do I want to see it? Yes, I do. Is it going to happen? Probably not. Probably not. Dawn says she thought everyone was out to get her because they charged her with perjury, and it turns out they were out to get her. But she did it to herself. So she doesn't like that. She doesn't like that at all. She fails to represent in any of her filings. There has been a judicial finding that she lied under oath and a looming criminal prosecution for perjury. A litigant who has demonstrated propensity to lie cannot be given a pass to litigate via unsworn paper or unchecked declarations. He's like, girl, no, no, no. Perry, perjury. I knew what you were saying, girl. It's fine. Berkeley, I'm sorry, Seichi says to Berkeley, yeah, perjury charges based on civil cases is super rare. Super rare. That's when you know. That's when you know you done fucked up. And especially when it's the judge that refers you for prosecution. Now, Owens is now a criminal defendant in Arizona. Respondent Marraccini is a material witness in that pending case. The state's, so this is how he's going to get witness intimidation, isn't it? I see what he's doing here. I see what you're doing here, I think. Respondent Marraccini is a material witness in that pending case. The state's disclosure explicitly lists Michael Marraccini as a witness in State versus Owen. Oh. Owens' aggressive pursuit of a renewed restraining order and her insistence on doing so via declaration appears calculated to harass and intimidate Marraccini in violation of the Penal Code. This isn't the first time she used this tactic. She already tried to have Marraccini arrested for violating the instant DVRO because he complied with a lawful subpoena where he was a listed witness. She claimed his appearance by lawful subpoena was the basis for her renewal. She failed to represent to the court Mike was complying with a lawful subpoena. That's true. She left that out. She's like, I don't know why he did it to harass me. It's awful. I had to sit so far away. By declaration. Just believe me, okay? Trust me, bro. Trust me. I'm so trustful. That's true. Berkeley Farms says the judge referring you for charges does tend to get the attention of the DA. It sure does. Sure does. And it sure did. Sure did. I can't wait for us to watch the Owens v. Eckert trial. We're close. We're close when we get back to that next week. We're not too far behind, I'm pretty sure. So, all right, where were we? Owens is dragging Marraccini back into court on baseless allegations to obtain an order that would paint him as an abuser forever. Owens sends a clear message. If you cooperate with law enforcement against me, I will continue to make your life hell in court. And it's a very clear message indeed, Omar. I think she's still doing it. Well, she is still doing it. There's no thinking. That's exactly what's happening. This raises the specter of witness intimidation. Know it. The timing is suspect. Owens let the prior 5-year DVRO renewal run its course until just weeks after she was indicted and officially learned that Marraccini could testify about her past lies. Oh, that makes a lot of sense. I guess that in the timeline, yeah. That would have, because what, she got the first charges, I want to say it was like May 2025. And so this was filed like July 10th, 2025, something like that, 9th. Let's see. Then she suddenly moved to extend the DVRO, which was about to expire, and concurrently sought to eliminate live testimony at the hearing. The inference is unmistakable. Owens wants to discredit Marraccini and undermine his standing as a witness against her. This is an outrageous perversion of the DVPA. The DVRO system is meant to protect victims, not to be wielded as a litigation weapon against someone who might testify in another proceeding. Courts have repeatedly warned against using restraining orders as tactical weapons rather than shields. Ooh, bravo. That was very, yes. Yes, that's exactly what she was trying to do. Granting Owens renewal on the manufactured premise of continued fear would reward her misuse of the system and tactically endorse a form of legal bullying. Ooh, I like that you used that word, Omar. Legal bullying. It's exactly what it is. It's exactly. Oh, that's good. Right? But I can't appear in person because I'm like so scared. It's too scary. Like, oh my gosh. She's ridiculous. And Dawn says, I think Laura really missed an opportunity when she wanted to change her name to Emily because Karen would fit her so much better. That's true. Oh my gosh. What could be more egregious? Let's see. Oh, speaking of, sorry. Y'all, I did. Wow. A lot of stuff happened when I was gone, by the way, which I did not appreciate. The world, I just needed to pause because while I was gone, lots of news broke everywhere. If you have not seen The latest Karen Reed filing for that civil suit between Proctor and Good and those texts. Holy shit. Wow. She's going to make all sorts of money off of that. They like have upended it's talk about a shit show. Indeed. So, if you don't know what I'm talking about, go find it. Like, I don't even want to say. I'm kind of glad it happened when I was gone, so I didn't have to like read tons of people have covered it, so I don't need to. You go listen to them say those words, because holy shit. What could be more egregious? Indeed. Stuff was popping off. Yes. Max Stevens said, so gross. It's so gross. So gross. You're protesting and giving the bird to Canton PD every walk by. Like, how? Corruption's everywhere, you guys. Of course it is. But for them to be so fucking blatant about it, it's a conversation for a different day, Llama. I'm very excited to talk to you guys. Can you tell? I'm just like sidetracked. I missed you all so much. It's crazy. Oh, they're so bad. They're so bad. You want to know what's in Kevin Albert's phone? All of them. All their phones. I need it all. Anyway, okay. Back, Steve. Thanks for doing the Lord's work. Oh, the Carmelo Anthony. That started too. I'm definitely not caught up on Carmelo to even talk about that case for sure. Oh, wow. Went to the same high school. Oof. They're all kids. So it is, you know. All right. Back to this. Llama, quit getting so distracted all the time. All right, so part 4. Owens failed to disclose she might not be able to give live testimony as she is barred from leaving the state of Arizona due to her felony indictment. That's enough. I didn't even think about that. I didn't even think that she couldn't. Well, she could get permission to leave, but they're not going to deny you to leave if you have to go do a court case. But thank you for bringing that up. Appreciate that, Omar. All right. So Owens is currently subject to an order of release from Maricopa County Superior Court, Arizona, in connection with 7 felony charges, including perjury, forgery, and evidence tampering, arising directly from fabricated claims nearly identical to those she is now asserting here. Like, almost as identical as her invisible twins. They could have been. We don't know. We don't know. Do we? Of whether she was claiming they were identical or not, fraternal. Oh, the boy and girl ones would have to be fraternal, though, because that's how that works. So, weren't they all like boy, girl? I think so. Her made up ones. Let's see. Standard conditions of such or releases generally prohibit defendants from leaving the state absent explicit judicial permission. Owens' physical appearance in California to participate in a contested evidentiary hearing requires prior approval from the Arizona Criminal Court. To seek that approval, she'd have to alert the criminal court that she is currently engaged in the same criminal behavior that she is facing 33 years in state prison for in Arizona. Yeah, you're going to have to tell them what you're doing. That's true. The underlying facts of this case necessarily form part of the foundation for the criminal case against her in Arizona. The Arizona indictment is related to Owens' history of fabricating evidence and submitting false statements under oath. To participate live in these proceedings, Owens will have to convince the Arizona criminal courts to travel out of state so she can participate in the proceeding to continue criminal conduct that gave rise to her felony charges. It is exceedingly unlikely that the Arizona court would authorize such travel. Would it be, though? I don't know. I really thought about that. This continued criminal conduct should be referred to the local district attorney for criminal prosecution, as Owens' behavior continues to put individuals at risk of further victimization. This court should not implicitly endorse Owens' attempted evasion of her or conditions by allowing her to proceed on paper alone. I think he's just saying this so that way she'd be like, I can't do that, so I can only do via Zoom, because she has a history of that. So, she gets to go to San Diego whenever she wants, but San Francisco for a court case? No, not at all. They allowed her to travel every time she's asked. I mean, I don't really know a lot of people that aren't allowed to travel during that. They're pretty lenient, unless you got one of those ankle cuffs. Then they're like, no, 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 no. Sagie's, hi. I need to leave to harass a witness on the prosecution's witness list. Okay, thanks. Bye. All the best, Laura. What was I watching this week? And somebody said all the best, and I was like, I looked up, like, what? I think it had to have been Real Housewives. It's either that or Silo, because that's all I've been watching this week. But one of them said all the best, like 3 times, and I was like, no. Okay, yes, so it was fraternal twins. Thank you, Don, for that. Okay, wow. Now, wait, did I finish that one? Yes, I did. Additionally, this court cannot ignore Owens' documented record of dishonesty, forgery, and perjury. See Judge Mata's judicial findings, Exhibit B. I love that. I haven't read those yet, obviously, because we haven't gotten there, but I like how he's like, how about you read, Your Honor, what this other honor wrote about her in a different case. In case you're not believing me, maybe you might, a colleague. Given this context, permitting Owens to avoid live testimony would be extraordinarily prejudicial. Her declarations, unchecked by immediate cross-examination, would shield her from confronting demonstrable contradictions and fabrications. Moreover, given her OR conditions, Owens' ability even to physically appear at a hearing in California is doubtful without judicial authorization from Arizona. Authorization that no responsible court would likely grant under these circumstances. Oh, and now I need to know. I know she's been allowed to travel, go do whatever she wants. Was she given the right to travel for this at any point in time? There might be documents, but I might have just put those aside for later future use. So right, please let me travel, please. Right, show up in court in person. No, not that. Don't want that at all. It's too scary. People will be staring, and we know how she finds staring to be very scary. Motion to seal should be denied. Owens' bid to seal the proceedings conflicts with California's strong presumption of open courts, as court records and hearings are presumptively public under California law. But they don't like filming them, and they don't like putting documents on the internet. You gotta show up in person. It's very annoying. Very annoying. Oh, she never asked for permission. Of course she didn't. I don't know what I was expecting to hear. Berkeley says she didn't ask last time. I don't think she had caught charges before. Oh, interesting. California Rules of Court explicitly states that court records are presumed open unless confidentiality is required by law. This principle is rooted in the public's First Amendment right to access court records, which Laura does not like. She does not like things being public in courts. Remember, they're putting all of this private court information on the internet. No, Emily can go get them, Laura. Under Rule 2.550, a trial court may order a record sealed only if it makes express factual findings that 1, there exists an overriding interest that overcomes the right of public access, 2, the overriding interest supports sealing the record, 3, a substantial probability exists that the overriding interest will be prejudiced if the record is not sealed. And 4, the proposed sealings is narrowly tailored. And 5, no less restrictive means exists to achieve the overriding interest. These requirements ensure that sealing orders are narrowly tailored and supported by compelling reasons. Now, Zoe woke up, so I gotta go let her outside real quick, but I'm not gonna do memes. I'll be back in well, actually, you know what? No, I am going to refill my coffee. So you're gonna get memes for just a few minutes while I let my dogs out and go get coffee. Oh, hi, Liz. I love you too, babes. Hope you're doing well over there. Happy to see you here. All right, entertain yourselves with some memes and dance party for like 2 minutes. All right, let's see. Which one do we want to pick? Let's pick 2. Okay, friends. Sorry about that. Okay. She's busy out there. But I knew the minute I sit down, she would scratch at that door to come in. So I just let her do my business. All right. I hope you guys enjoyed that dance party. Thank you. for being so patient. Appreciate you. It makes you happy. I love that you love that song. I do too. Hopefully that brought you all some laughs and smiles on your face. All right, so back to where we were. So she wants everything sealed, which she does this with every case, and she has been rejected just about every time for sealing the records because the crazy cult on the internet posts all of her personal things. But it doesn't really make any sense for her to have any of this sealed. I mean, even in murder cases, like it has to be something to get some things under seal or a gag order. Well, gag orders are pretty fine, but whatever. Those are pretty easy to get, it seems like. Oh yeah, you guys, I forgot. If you haven't, please do like this stream. It lets everyone know that we're live and that this is where the dance party is today and that Llama's back. And if you're new, please hit the subscribe button, hit the notification bell. We do lots of things on this channel all of the time. So that way you never miss when we go live or drop an episode of one of our mini shows. All right, so back to trying to seal the record here. These stringent requirements codify constitutional standards and make clear that sealing is the rare exception, not the rule. But Laura thinks she is rare at everything. Don't forget, everything about her is so rare and special always. Just smash that like button. Everybody be like, sit cheese. Sit cheese. Now, petitioner has not come close to meeting this heavy burden. She identifies no overriding interest sufficient to overcome the fundamental presumption of open access. Her claimed basis for secrecy is not the protection of any legitimate privacy interest, but rather an effort to shield herself from public scrutiny, avoid embarrassment from challenges to her credibility, and prevent the public from observing her ongoing criminal conduct. That's nailed it. Put 3 nails in that coffin, Omar. She is a horse princess. She is a horse princess. Owens has actively publicized the very allegations at issues in this case. Exactly. She made a whole TED Talks and wrote about it. By her own account, Laura has openly discussed her relationship and abuse claims in public forums, including a TEDx talk in January 2022, describing how a note from a stranger prompted her to leave an abusive boyfriend, a reference to Marraccini. She has published essays and made media appearances touting her status as a domestic violence survivor, voluntarily disclosing details of the alleged abuse. She also initiated prior litigation in 2018, a domestic violence restraining order case based on those allegations, which was heard in open court and resulted in public court records. Having freely injected her story into the public sphere, Laura cannot now credibly claim a compelling privacy interest in shielding the same narrative from public view. Well, but silly Omar, she can talk about it, but she doesn't want him to talk about it. When she was filing like her renewal request, you remember when she was like, and the internet keeps calling him the victim, keeps calling all these men victims and not me. Well, horsey girl. There's only one horsey girl that I love, and that's Tina Belcher. She's the only horsey girl that I absolutely love. But that's probably because I really feel Tina Belcher from Bob's Burgers daily. Let's see. This one-sided use of secrets. Okay, yes. Owens has painted Marraccini as an abuser in the court of public opinion through interviews, online posts, and public talks. Yet she seeks to close the courtroom doors and keep the actual evidence and testimony hidden from the same public. This one-sided use of secrecy would severely hamper Marraccini's claim to clear his name. Fundamental fairness dictates that Marraccini be allowed to rebut Laura's allegations in an open forum so that the truth can emerge. The California rules recognize that transparency is crucial not only for public confidence in the courts, but also for the integrity of the fact finding process. Laura's attempt to seal the record is an effort to control the narrative. That's in bold for a reason, and avoid having her claims tested under the glare of public scrutiny. The court should emphatically reject this request. I agree. I agree. Oh, what? Hit a nerve in your spine? You're in the hospital, Liz? Oh my goodness. Oh my goodness. I did not know that. You might have said it earlier and I might have missed it. Oh, I hope you're okay. We're here for you. We're here for you to support you and entertain you. Also, I just want to point out the month of June sucks. Okay. The only thing that's so exciting about June is this fundraiser we're doing on Saturday, but everything about this month so far, not a fan. Not a fan. You have a couple titles for her. Fraud, malinger, perpetrator, perjurer. Those are excellent words, Lainey. Excellent. Excellent words. Text packet. Oh, look, hey. Hope you're doing well, girl. It just took me like 30 minutes to get the chat to come up. YouTube hates your butt today. Oh, pesky YouTube. Pesky YouTube. Yes, we're all here to cheer Liz up. So I'm glad that we can do that for you. All right. Point 6. Relief requested. Evidentiary hearing sanctions for bad faith and referral for a criminal investigation. 1. They want deny Laura's motion to proceed by declaration and order that the hearing go forward with live testimony after proper service has been effectuated. Both parties and any other permitted witnesses should be ordered to testify under oath, subject to cross-examination. 2, deny Laura's motion to seal because it's bullshit. Laura has not met the stringent criteria of the rules, and the First Amendment and common law rights of public access would be unjustifiably infringed by the blanket secrecy she seeks. 3, impose sanctions on Laura for bad faith litigation conduct. Owens' litigation tactics, including failing to serve her opponent, attempting to mislead the court, and persisting in claims known to be false, have needlessly increased the cost of this litigation and undermined the policy of cooperative resolution. Now, if she goes after Mike again, which I heard she said as such, we're probably going to hear these same points by whatever lawyer is doing that case, because it's literally the same. Refer Laura's conduct to the district attorney. Oh, this is my favorite point. For possible criminal investigation. The evidence before this court suggests that Owens' actions are not merely civilly actionable, but criminal. The court should consider making a formal referral or recommendation to the San Francisco District Attorney's Office to investigate Owens for perjury, offering false evidence, and witness intimidation, among any other applicable offenses. I mean, if she keeps pushing her luck, that's exactly what's going to happen. Respondent Michael Marraccini respectfully urges the court to deny Laura's motion to proceed by declaration and to order that the matter proceed with live testimony pursuant to Family Code 217. Furthermore, Marraccini asked the court to send a clear message by imposing sanctions on Owens for her bad faith litigation conduct and by referring the evidence of her perjury and intimidation attempts to the district attorney. Owens' ongoing insidious manipulation of legal processes must end. Ooh, I love that last line, Omar. Ended that with a banger. Lobster claws for you, Omar. That was pretty good. Good job. When did she fail to serve, Mike? Right after she filed. It would have been in July. It was close to, I want to say it was like July 22nd through the 26th of 2025. Because I think it was Friday we had read the process servers filing of trying to get in contact, but either nobody was home or just Mike's wife was home with the newborn baby. And remember, they were all just like, I think he's trying to avoid things because it sounded like he was on a work trip. But so it was before August 1st. I want to say the last week of July. So let's see here. Oh, thank you, Liz. Oh, flowers back to you as well, Liz. Thank you for the super chat. You're so kind. I appreciate that. I love his adjectives: blatant, insidious, all of them. Oh, Terry, can we get Omar and Alan Jackson together? Oh, that'd be amazing. That would be amazing. Oh, also, speaking of, again, back to the Karen Reed and Michael Proctor stuff, I forgot he is supposed to be deposed today. Yeah? Is that still happening? Because now I think about it, I think somebody said he was like, well, I can't go. I wonder why. Is that still going on or not? You remember now? Don't worry. My memory is like, I don't know when things happen. Yes, get healed up and back to things. Back to us quickly, Liz. Back to us. All right, so that is the end of that document. The rest of everything in here we've already read, or it's not really relevant. So we have a lot to relevant for the fundraiser, I should say. But we'll get back to whatever we don't read when we arrive in 2020. Now, this one is kind of a long one, but I think we can do it. It's not Alan, it's Zaddy. I'm sorry. I'm sorry, Terry. Don't look at her. She's like, well, you're back and I'm going to yell at you. Just kidding. Oh, I'm just kidding. There was a hearing a couple of hours ago. Oh, regarding Proctor. I'm fixing to look what happened there right now. Ooh, thank you. Berkeley says it's not happening today. There was an emergency motion on. Of course, there was. Like, sir, just get it over with. All right, just get it over with. It's happening either way. Just fucking do it. Of course he is. And the judge will rule in the afternoon? Ugh. That case is a mess. All right, so over here, this is, what am I reading? I don't even know what I'm reading. I am reading, again, this is Mike and Omar's motion to dismiss the DVRO pursuant to some rules, notice of intent to seek sanctions, and the declaration by Omar, but we're only reading about 20 pages from page 6 to 26. So this is them arguing, like, judge, just drop this case. Let's not waste everybody's time. This is all a bunch of fucking bullshit. So if you could just rule to dismiss that, put sanctions on her for doing this in the first place, you know, we're going to seek them. Even if you rule this out, we're going to seek them. But just, how about we just do that? And then a declaration by Omar, but that's not really, you know, relevant to anything. I don't think we're reading that. So Buffy said EDB was in the hearing this morning. In the hearing? Was she there? Like in person? If you have the Law Nerd app, she sent out a long explanation of what happened. Well, Buffy, I don't. And that's what I have you for. Oh, I didn't know that. Oh. Was Karen on the Today Show? Ooh. Oh, interesting. Interesting. Oh, it's a crap interview? Oh, she listened by Zoom. Oh, it was on Zoom. Okay. I mean, she has the money to travel. It is EDV we're talking about. She could probably get in anywhere. Like, do you know who I am? Oh, wow. The interview on the Today Show was a disaster. They clearly dislike her and did no good things to make the damn interview. Oh, that's interesting. Okay. All right, let's get to this. Because yeah, I have that. All right, so I am sharing the right one. Okay, so this is a little bit more backstory in case you're catching us for the first time here. If you are, We have a whole entire Laura Owens playlist. I don't know how many videos we have on there right now, like 30 something, 8. I don't know. Are we to 40 yet? Probably. By the end of the week, for sure, if we're not already. But we've covered everything in timeline order, with the exception of this, because we have the fundraiser coming. But if you don't know what all went down in 2018 and 2020 with Mike Marraccini, are at the very beginning of our playlist, you'll see 4 Michael Marraccini episodes, and those really go into detail of all the court filings that were filed all that time. I recommend giving that a listen to before the fundraiser as well. There's lots of text thread, both from Laura, but her parents. It was tough to read those because she sucks so much. Oh, lots of drama with the Today Show interview. They told her that people don't like her. You think she doesn't know that? Like, breaking news, Today Show. Half the people don't like Karen Reed. Oh, jeez. I mean, it's a Today Show, whatever. And then they wonder why their ratings are bad for things. Anyway, say cheese. Yes, that's right. I forgot we were talking about that over the weekend. Karen Reed is a rabbit hole I'm not sure I want to go down. Actually, it is fascinating. I know I already told you that on the Discord, but like, the lawyering is fucking top notch. I've never seen anything like it, but the amount of corruption that happens in real time in these trials, like, you have to at least watch. You don't have to go down all the side rabbit holes, say cheese, but like, watch the trials. Worth it. Now, the Karen Reed one's very long. I think what I calculated, it was like 212 hours of streaming I did for her second trial. That we watched some of the first trial when they were on breaks and stuff. So it is quite a dedication, but you will not be bored. I can tell you that. So, good times there. Oh, goodness. I would have been yelling at the Today Show, probably. It seems like it'll take forever. Well, yeah, but it's wild to see. And listen, I believe she is factually innocent. Many people believe she is factually innocent. And it is wild that even the lengths the prosecutors were willing to go, the state was willing to go. It was wild. Did not like it. And it could have been any one of us that they did it to. So that's the only reason why I always work. I mean, I know you're in law as well, but it's crazy. My friends have been trying to get me to watch it for like a year, and the second one was coming up, and they're like, "Llama, you are going to lose your shit." And they were wrong. They were wrong at all. Oh man, just awful. Just awful. All right. Where were you? Okay, so respondent Michael Marraccini moves to vacate the domestic violence restraining order obtained by petitioner Laura Owens in January 2018 on the grounds that the order was procured through fraud. What has become abundantly clear from all filings addressing Owens' requested renewal of the underlying DVRO is one fundamental truth. Laura Owens will not be able to refute evidence based on Owens' admissions, independent witness statement, findings from separate court proceedings, a recent felony indictment for fraudulent schemes, perjury, and submitting false evidence, which proves Owens' fabrication of allegations of abuse and the presentation of false evidence to obtain the 2018 restraining order. That's a very long sentence. In doing so, Owens deprived Marraccini of a fair opportunity to defend against the DVRO, satisfying the definition of extrinsic fraud that warrants equitable relief. Oh, okay. That is a strong opening. More like, ain't this some shit? Okay. Marraccini, compelled by the concealment of material facts of Laura Owens' schemes stipulated to the DVRO. He now stands resolute in asking this court to vacate the fraudulently obtained order in the interest of justice, ending a 7-year-old prejudicial I haven't read things in a long time, can you tell? Restraint on his freedoms, on his liberties, that Owens has used to taunt him wherever he goes. Owens, seeped in animosity, the unearned robes afforded to genuine victims of abuse and criminal intent, has sought Marraccini out to affect his life in any possible way. Oh. Marraccini has moved on. He started a family with a beautiful wife, facts, and children, also facts. He has lived a crime-free life full of love and affection from those he actively supports. He's moved on in every imaginable capacity. But for Owen's criminally inspired request to grasp at the ghost of a relationship she relentlessly coveted, that Marraccini wants to erase from existence. CCP 473 affords him that opportunity. Oh, I do love how he pointed out how just he is happy and moved on with his life, and she just won't let shit go at all. Let's see. Factual and procedural background. Here's some more history. I don't know if any of it will be new, but maybe not. Maybe so. All right. So Owens and Marraccini were in an on and off again relationship from 2016 until mid 2017. On January 7th, 2018, an incident occurred in which Owens confronted Marraccini and his sister in public, screaming accusations at Marraccini, prompting him to ultimately call the police to defuse the situation. Now, 2 days later, on January 9th, 2018, Owens filed a request for a domestic violence restraining order in this court, which the court granted on a temporary basis on January 10th, 2018. Owens' application for the DVRO alleged that Marraccini subjected her to extreme physical and emotional violence over the course of their relationship. No. Oh man, you remember when we read her like 2018 bullshit? It was so weird. So weird and creepy and didn't like it. Had to say a lot of words. Ugh. 3. Owens submitted photographs of injuries that she claimed were caused by Marraccini's abuse, when in fact those photos were from an unrelated accident. Owens falling off a horse, which she does a lot. I don't have horses. I've only been on a horse once, but how often do riders fall off their horse? Is this a common thing? Or is she just like the clumsiest person in the world that constantly falls off a horse? Because I imagine if it's something that like you fall off quite often, that's kind of dangerous. Okay. Oh, wait, I was not done with that. Owens also claimed the abuse was so severe it drove her to seek inpatient psychiatric treatment, a claim which she herself had contradicted in prior filings. That she did. Marraccini categorically denied Owens' allegations. On January 22nd, 2018, Marraccini filed his DV-120 response, refuting every claim and alerting the court to Owens' history of manipulative conduct, including instances where Owens had fabricated pregnancies and made conflicting medical claims during their relationship. And this was years before Greg, years before Clayton. Well, that's exactly what she did. Let's see. What do you guys say about the horses? Not a horse person, but it does happen. Okay. I feel like she's fallen off a horse like 100 times already in the storyline. Like, oh my goodness. Dawn says, I love that Mike is having a happy life and Laura is sitting in a mess of her own making, playing with crap and slinging it against the wall. Amen, sister. I do love self-fulfilling prophecies, don't you? Puppy, I think you're supposed to stay on the horse. What do we know? We don't get that pony money. Horse accidents used to be a significant cause of death. I would think so. I mean, that's why modern riders wear helmets. But like, you don't fall off a bike constantly. I feel like she's always falling off these horses. You've never fallen off your horse. Oh, that's funny. Okay. You just had a new baby text packet. Woohoo! We just had a new baby calf across the road. Oh, I had to get up and make sure that's what I was seeing. Oh, I love that. It's gross. I have seen a baby cow being born. It's real gross, but it's also cute. I like, there's a few channels that I don't watch much anymore, but I used to, of just like, what were they? Were they goats? Maybe they were goats or sheep or something like that. But they were going to be having lots of babies. And it was like watching like each day to see how, and then they had babies. And it was so cute. I was like, oh my God. And then I'm like, Mama, you spend so much time just watching barnyard animals on YouTube. What are you doing? But it was cute. And I had to know what they were going to be. And they were adorable. People that jump bikes fall off more than normal bikes. Okay, true. If a horse balks at a jump, the rider gets dumped. Oh, okay. You've ridden a horse a few handful of times. Oh, here's that appointment I was telling you guys about. Let me give you some memes. I will be right back. I'm so sorry. Okay, friends, I'm back. Thank you for being patient with me. She actually called earlier than I was expecting, but she's one of those doctors that kind of like make a window appointment. She'll be like, I'm going to call you at any time between 11 a.m. and 1 p.m., which not a fan of. Not a fan of that at all, but I understand she's very busy lady. However, it's also one of those that if you miss the call, good luck trying to get a hold of them again. And I don't know. I don't love it. It's like, ma'am, I know you know about my anxiety. And I don't know if this is some exposure therapy or something, but I don't like it. I need to know what time things are. But all right, no more dance parties today, I don't think. But again, thank you guys for being patient there. All right. Oh, it's hot. It's hot. You got your blood pressure up to 120. I love it. You guys are gonna get those summer bods real quick with the dance parties. All right. So where was I? There we go. All right. So we read that. So Marraccini categorically denied Owens' allegations on. Oh wait, I already read that. My apologies. Both parties submitted additional declarations and some third-party witness statements in preparation for an evidentiary hearing on the DVRO. The evidentiary hearing, originally set for January 26, 2018, was continued to allow discovery, including deposition of the parties and further evidence gathering. And I remember what really pissed me off about this whole thing with Mike specifically, because this is the DVRO case, is that she did use the resources of that are available to victims to help them get these, right? It's like a whole system or extra thing that you get if you're a victim, and they'll help you go through the court process of like obtaining these. So like she gets a lot of help in 2018 where Mike has to pay out of pocket for everything. And while that is great in some circumstances, this bitch has a bunch of money, so she didn't need to do that. And two, none of this ever happened. And that just really, really pisses me off because, you know, those are kind of departments that don't get near as much funding as needed. Unfortunately, there's lots of need for those departments, but still pisses me off that she used those resources for lies and bullshit. So by July 2018, Marraccini was emotionally and financially exhausted due to Laura's barrage of false narratives. Barrage? I'm going with barrage. Sounds fun for today. Why not? Barrage of false narratives. Rather than continue to engage with what he knew were baseless accusations, Marraccini made the practical decision to resolve the matter by stipulation. Oh, dismiss phone. Thank you. On or about July 10th, 2018, Marraccini, simply wishing to move on, agreed to enter into a stipulated restraining order, resulting in the issuance of a 2-year DVRO through July 10th, 2020, with no admissions of wrongdoing and no factual findings against him. Probably the worst decision. But him, and he had a lawyer, right? Randy Sue Pollock, I think, was his lawyer, but they also didn't know who they were dealing with. I get where they're like, you know what, fuck it, we'll just stipulate. I don't plan on ever talking to her. I'm not going to do anything. Who cares? Right? And under normal circumstances, makes sense. But Laura is not a normal person. So, let's see. Oh, you guys. Oh, so there are some horsey people in the chat. I like that. Lady in Gray says she stole resources and made things harder for true victims. I hate this bitch. Me too, girl. Me too. Pisses me off. The 2018 DVRO was issued without any finding that Marraccini committed domestic violence. The July 2018 stipulated DVRO was set to expire on July 10th, 2020. On that date, petitioner Owens sought a renewal of the restraining order for an additional 5 years. And Buffy and I read the transcript of that, and it was annoying as shit because Mike was just himself. He did not have any representation. And basically, at this point, if I remember the understanding correctly, at this point, it was just she just had a fear that something might happen, and that was good enough to renew it for 5 years. And it was very hard hearing him try to, well, we were reading it, but him talking to the judge, like, I don't think I need this. There's no reason, but it really wasn't about anything he had to say. It was literally, are you still afraid of him? Oh, it's working then, right? Because he hasn't contacted you and you're still afraid. Okay, here you go. Here's another 5-year extension. It was quite frankly a bunch of bullshit, in my opinion. But, okay. The court granted Laura's renewal request on September 11th, 2020, extending the DVRO to July 10th, 2025. Laura has since treated the existence of the DVRO as a tool to bolster her self-portrayal as a domestic violence survivor, which is exactly why I don't think she's ever going to let it go. Because between 2021 and 2024, Laura made multiple public statements referencing the restraining order and accusing Marraccini of heinous abuse, including a TEDx talk in January 2022, and even a published essay, which was later removed due to questions about its credibility. I think that's the chicken soup for the soul one there. Now, in 2021 and 2023, Laura became involved in litigation in Arizona, where she accused at least 2 other men of abuse after falsely claiming to be pregnant with their children, strikingly similar to her modus operandi with the Marraccini. In one case, Owens obtained a protective order against a man, Greg Gillespie, after he ended their relationship, which is also on our Laura Owens playlist. If you don't know much about that one's just as fucking crazy. In another, she obtained a restraining order and filed a paternity suit against a former Bachelor TV show star, Clayton Echard, following an alleged twin pregnancy. These out-of-state matters culminated in June 2024, when the Maricopa County Superior Court in Arizona conducted a trial on Laura's paternity claims against Mr. Echard. Well, it did not go well for her. She's so scared, guys. She's so scared. Hi, Barbecue Queen. Hello. Hope you're doing well. So happy to see you. Oh, and Bacon Boots. I don't know if you've been in here before. Well, I've been in here other days. I meant before I had my phone call. Hello. Happy to see you here as well. Love you guys. Thanks for being here. Now, in that proceeding, oh, well. In that proceeding, evidence was presented that Laura had never been pregnant at all, that she had fabricated evidence, including bogus positive pregnancy tests and doctored medical records, and that she had lied under oath in support of her claims. Now, the Arizona court expressly found that Owens had provided false testimony and that her petition was fraudulent as part of a pattern of similar, if not identical, behavior in comparison to her prior schemes. The court noted that Owens' claims were not credible and had been concocted to manipulate the targets of her accusations. Laura was ordered to pay over $149,000 in attorney fees to Mr. Echard as a result of her bad faith, fraudulent conduct. Oh, I can't wait till we watch that. So excited. I know, right? Terry comes crashing in behind the scenes. She's like, oh no, wrong show to get ready for. That's okay. It is so nice to see her pretty face. Now, shortly thereafter, in May 2025, Laura was indicted by a grand jury in Arizona on 7 felony counts, including fraudulent schemes, perjury, forgery, and evidence tampering, all arising from her elaborate false pregnancy and abuse scams in the Echard matter. I love how much they say scams. It is against this backdrop that Laura filed yet another request to renew her DVRO against Marraccini on or about July 10th, 2025, seeking to extend the restraining order permanently as the July 2025 expiration approached. Owens' renewal request is set for a hearing in October 2025. Marraccini has opposed the renewal and now additionally brings an immediate motion to vacate the original DVRO on the grounds of extrinsic fraud, citing newly discovered evidence that was unavailable at the time of the 2018 stipulation. Ooh, what is that? Oh, by the way, I forgot to say this was filed September 11th, 2025. So a couple weeks after the last one we read. Sorry, I forgot to tell when this was. Let's see. Virtual Juror says, well, I mean, has Omar clocked that the 2 positive tests she sent Mike were the same? I don't know. I need to know. I need to know all the things now. 19. New evidence of extrinsic fraud, including unknown evidence from the 2018 stipulation, allows this court to vacate the 2018 orders that have been obtained through mistake or excusable neglect, based on what is now known to be Laura Owens' fraudulent scheme perfected over the course of nearly a decade. Oh, I bet it was stuff that came from his laptop. Oh, probably the doctor's notes. Well, your boyfriend should be. I bet that's what they're talking about. The evidence now available paints a devastating picture of Laura's lack of truthfulness and her abuse of the judicial process. Marraccini urges the court to consider the full evidentiary record, which was not available at the time of the 2018 DVRO, and to exercise its authority to vacate an order that was fundamentally built on fraud. So points and authorities, relief under CCP 473 and equitable power. Courts have the authorities to set aside void judgments or orders upon motion by either party after notice to the other party. So this is where they're like, how about you just dismiss this because this is ridiculous and dismiss it all the way back. Notice has been achieved under the instant case by virtue of Marraccini's filed response to Owens' DVRO renewal request filed August 25th, 2025, and through this file motion. There's a bunch of law stuff there, blah, blah, blah. We're not going to read that. In addition to statutory authority, courts possess inherent equitable powers to set aside judgments obtained through extrinsic fraud or mistake, even when statutory deadlines have expired. Oh, okay. So this definitely has to be about all the laptop stuff. Extrinsic fraud occurs when a party is prevented from fully participating in the case due to deception or misconduct by the opposing party, such as being kept in ignorance of the proceedings or being misled into not defending the case. Oh, I wonder if they got stuff from the investigators' report too for the charges, the felony charges. So if Mike is a witness for the felony charges during this time, when Omar is representing him in California, is Omar as a lawyer like privy to asking the state of Arizona for information regarding his client, even though he's just a witness in that one? Or how does that work? I don't know if I've done anything for separate states. Is that a doable thing? I know we got some lawyers and shit. We got some legal people in here. Or is it you not anything because Mike's a witness? So you wouldn't want to like tamper there. But you can have a lawyer when you're a witness. Think of the Karen Reed people. I don't know. I don't know how any of that works. Okay. Let's see. Opposing parties. Okay. Extrinsic fraud occurs when a party is prevented from fully I already read that every time. And that's okay. The distinction between extrinsic and intrinsic intrinsic fraud is critical. Intrinsic fraud, such as perjury or forged evidence, and there is certainly plenty of that in this case. Love that. Omar. Presented during the trial does not warrant equitable relief because the affected party had the opportunity to address it during the proceedings. In contrast, extrinsic fraud involves circumstances that prevent a fair trial, such as a lack of notice or deliberate concealment of material facts. Extrinsic fraud must relate to the manner in which the judgment was procured, not the issues decided in the judgment. And then they cited case law. In addition, the courts have recognized that the terms extrinsic fraud and extrinsic mistake are broadly interpreted to encompass circumstances that deprive a party of a fair hearing, even if the circumstances do not strictly qualify as fraud or mistake. Oh, okay. The principle was discussed in this case, in a separate case, and reaffirmed in subsequent cases. Interesting. California courts have constantly articulated a three-part test for granting equitable relief from a judgment on the grounds of extrinsic fraud or mistake. Oh, three-part test. Okay, I did not study for this, but okay. The moving party must demonstrate 1, a meritorious defense to the claims upon which the judgment was entered. Okay. 2, a satisfactory excuse for not fully presenting that defense in the original action. And 3, diligence in seeking relief once the fraud or mistake was covered. So they're like, hey, we have done all of these things. So, okay. The courts have also clarified that while there is no strict deadline for filing a motion based on extrinsic fraud or mistake, the motion must be made within a reasonable time after the fraud or mistake is discovered. This requirement is closely tied to the principle of avoiding prejudice to the opposing party, as highlighted in these other cases. A domestic violence restraining order, though civil in nature, is a serious order often made under expedited circumstances. They are usually very quick cases. Very, very quick. Oh, Say Cheese has an answer for my question. I had to rewind your question. Omar could reach out to the DA's office, but isn't licensed in Arizona. So it would be to request information. So if the San Francisco case and up to the DA, whether they could cooperate. Okay. All right. That makes sense. Kind of no harm in asking, but they could be told no. So, okay. Gotcha. Thank you for answering that question. I appreciate it. Hello, Polly. Good morning. I missed you. So happy to see you here. Stacey says, but also giving the DA heads up that she is legally going after a witness on their list. Oh, that's true. Okay, by the way, we might have some more info for you. Especially since that's one of their witnesses. Yeah, that's true. Fair point. Thank you for answering those for me. Now, a DVRO obtained through extrinsic fraud may be vacated in equity. If a court finds that a restraining order was procured through deception or false evidence, the proper remedy is to set it aside, thereby preserving the integrity of the court's processes. The policy favoring finality of judgment yields to fraud that undermines the fairness of the original proceeding. This court has the authority and duty to vacate a DVRO if evidence shows it was obtained by extrinsic fraud. I mean, because, yeah, this is what, 8 years after it's filed. So they can still use that stuff to be like, yeah, no, it was all bogus to begin with. Argument that Marraccini is not time barred. Okay. So this code provides that a motion for relief from judgment, order, or proceeding must be made within 6 months of the entry of the judgment or order. This 6-month limitation is jurisdictional and cannot be extended under ordinary circumstances. However, California courts recognize an exemption to this limitation in cases involving extrinsic fraud or extrinsic mistake. Okay. Marraccini challenges the 2018 DVRO under California Code of Civil Procedure and contests its subsequent renewals based on the lack of litigation, absence of finding of domestic violence, and the petitioner Owens' documented history of fraudulent conduct. So let's wipe it all away because it was all bogus. I asked you not to call me pretty lady. Oh, well, see, she can't help herself. Let's see. So this code, a party may seek relief from an order or judgment if it was obtained through mistake, inadvertence, surprise, or excusable neglect. The stipulated DVRO issued in 2018 was not litigated on its merits and was agreed to under duress and exhaustion, as he was emotionally and financially drained by Owens' false allegations. The stipulated order contained no findings of domestic violence, which weakens its evidentiary basis for renewal. And with the other cases of Greg and Clayton, the line that's, being emotionally and financially drained by Laura, like that's literally what she's done with everyone. It's just run up that money tab for everybody and just keep lying over and over and over again. I mean, court already, no matter what reason you go, sucks and is emotionally draining, no matter which side you're on of the court proceedings. It sucks. But as we've seen covering Laura, she will do everything she can to keep extending it and extending it and extending it. Gosh, sucks. Although statutory relief under 473 would normally be time barred, the doctrine of extrinsic fraud applies. Marraccini did not know and could not reasonably have known that Owens' conduct rose to the level of extrinsic fraud until recently. Owens' actions deprived him of a fair opportunity to present his defense through material concealment of material facts. I hope you're going to tell us what these are, which satisfies the criteria for equitable relief beyond the 6-month jurisdictional bar. In such cases, no statute of limitations applies, provided the aggrieved party seeks relief within a reasonable time. Now, on May 25th, 2025, Laura Owens was indicted on 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, and evidence tampering. Marraccini is a named witness in the state of Arizona's case against Owens. This indictment represents the first official corroboration that Owens' conduct was criminal in nature, and it provided Marraccini with confirmation of the extrinsic fraud that had previously deprived him of a fair trial. Okay, so we're using some of that to be like, yes, there's fraud going over here. Okay. Say Cheese says this is a really difficult argument to win, especially since Mike stipulated to the original order. That is true, because it's basically like pleading guilty to something. I see how it wasn't like brought up in the order, but and he was represented at the time, I do believe, by Randy or something like that. So. But I get it. Like you just want to be done with it. That's too bad. I wonder if I don't know how this ends, actually. I don't know if they get everything taken off from 2018 or they just don't renew it. I don't know. So we'll find out. Now, Owens sought renewal of the DVRO in July 2025, and Marraccini filed this motion in September 2025. Accordingly, the motion was brought within a reasonable time, satisfying the requirements of 473. All right. So the next section, Owens' pattern of deceit constitutes extrinsic fraud. Laura Owens has developed a scheme she frequently imposes on men she dates. So if you're watching this right now and Laura Owens has talked to you, you might want to take some notes and then run very, very far away. 1. Initial manipulation. Owens begins relationships quickly, fostering dependence with rapid discussions of family and commitment. Within months, she falsely claims pregnancy, manipulating photographs and documents to lend credence to her narrative. The takeaway: Owens expertly creates emotional traps, setting the stage for deeper deceit. I mean, this is all very true based on what we've seen and read. Crisis fabrication, which could be any of the following. Or all of the following, pretty much: miscarriage, abortion, inpatient mental health care, cancer, suicidal ideations, all of which were bullshit. None of them were true. Following the initial deceit, Owens invents medical emergencies such as miscarriages, offering fake evidence like manipulated test results. She assumes false identities to bolster these claims, fabricating correspondence from supposed allies or medical professionals to strengthen her lies. This step illustrates her meticulous crafting of fabricated crises to deepen her emotional control. Do any of you know somebody that's like that? Because I do. Where like it every single day of everything is a 10 for things that shouldn't be a 10. But that person just lives in a crisis world and they just make sure everybody knows about it all of the time. And it is, it's frustrating to say the least. Say Cheese says the strongest argument is that Mike didn't know about victim zero. Oh, yeah, that's true. I forget about him all the time. But yeah, that's true. He didn't know about that at all. That didn't, when does that came out in Clayton's, right? Because I know Greg knew about Mike Clayton, but I think that, oh, yeah, because it was a deposition that she dropped that name of Clay, like in her deposition with Clayton. So, yeah, oh, yeah. So that's a really good point. No, thanks. Some cases histrionic. Maybe so. Ugh. People are exhausting. It came out in the depot for Clayton. All right. Thank you, Bacon Boots. I appreciate you. False allegations. Owens then escalates by falsely accusing her partners of abuse, presenting unsubstantiated claims of assault and harassment. This includes submitting forged records and photographs as false evidence. Publicly posing as a victim allows her to promote her false narrative. In each instance, evidence contradicts her claims, as courts have often dismissed her lawsuits and noted her lack of credibility. The pattern demonstrates her consistent use of deceit as a means to manipulate those who dare reject her. Woman has so much spite, it's ridiculous. Barbecue Queen Boom Bump enters the chat. Lady in Gray wants to see Napkin Lady dragged into court. Me too. Me too. Assuming the identity of fake people. Owens assumes the identities of aliases or real individuals to support her conjured crises. For example, Dr. John C.K. Chan is an actual medical professional for whom Owens authored forged medical letters purporting to be from Dr. Chan, a gynecological oncologist, stating she had ovarian cancer and urging her partner to be supportive. We already read those. She forged notes from Dr. Rebecca Yee. Read those. Owens faked communications from entertainment manager David Katz in an attempt to mislead Marraccini into thinking Mr. Katz would represent him in his podcast venture with Owens. Oh, so that is all fake. I mean, I was told it was fake. Like, oh. Owens claimed to have friends and associates who supported her story of being pregnant with twins. The court later found these claims unsubstantiated. Well, when you put Laura and the word friends together, we pretty much know if they didn't exist at all. Echo says, yep. Oh, yep. Emotionally exhausting with such people where everyone needs to hear all the tales of woe. Yeah, or when like it's somebody's like special day and they just try to like take that away and make everything like they can't stand anybody else having intention for a day, right? And so it's like, oh, let's get everybody all worked up about nothing. Hi, Mama Llama. Yes, I'm back. First day back. Thank you. Happy to see you here. Barbecue Queen says, by the way, there was someone here that recommended a video on Low and Ron, and it was really eye-opening. Today? Oh, well, if so, let me know what that is. I might have missed it. Forged medical records and injury photos. To bolster her lies, Owens fabricates documents and recycles unrelated injuries as abuse evidence. Over a 10-year span, Owens manufactured medical proofs to prop false narratives, forging an oncology letter, Dr. John C.K. Chan, claiming an oophorectomy and surgical abortion via purported notes from Rebecca Yee, MD, texting HCG and oncology materials, and rebranding horsefall injuries as domestic violence bruises. In Arizona, investigators found she altered an ultrasound image and fabricated a pregnancy video, and filings show she submitted falsified medical records to her own expert. Because of course she did. A judge concluded she knowingly presented a false claim and referred her for prosecution. Yay! Now charged with fraud, forgery, perjury, and evidence tampering. Together, these items form a continuous pattern of medical evidence fakery used to mislead partners in courts. I wish there was like some sort of warning that would go out to doctors too, right? Like if you are convicted of fabricating evidence medical wise, that like other doctors would be like, no, thank you. Because what, you correspond with her one day and then she's using your entire identity, your letterhead, everything for her schemes. Where can you send it to me? Email it to me, babes. Yes, thank you. Thank you so much, Barbecue Queen. I appreciate it. Tara, T-A-R-A, at tcwtmedia.com. That's me. Now, 6 restraining orders, because if it wasn't already too much, she makes it even more. Over the past decade, Laura Owens has repeatedly presented herself as a victim of abuse, alleging physical assault, sexual assault, stalking, harassment, and pregnancy-related coercion by numerous men. In each known instance, however, her claims have been unsubstantiated, contradicted by evidence, or proven to be false outright. Courts have dismissed her lawsuits and, in the most egregious case, found that Owens fabricated evidence and lied under oath. Owens often makes such accusations reactively. Example, after a breakup or after the other party seeks help or legal action against her. And she frequently involves false pregnancies or health crises as part of the narrative. In several cases, Michael Marraccini in 2018, Greg Gillespie in 2021, and Clayton Eckert in 2023 obtained or attempted protective orders against the men only after they sought to distance themselves or took legal action against her. I mean, what are the odds somebody goes through all of that? What are the odds? Buffy. I heard my name and it freaked me out for a second. No, just this, Tara. Just this. Am I checking my email? Yes. I cleared it out, everything. And because we're having this fundraiser, so I am checking it. Terry. Don't make her check her email. She's been through enough. You get him, Dawn. You tell him. Give me a hard time. All right. Then 7, the public victim narrative. Owens then uses the existence of a DVRO or court filings to promote herself as a survivor in public forums, TEDx talks, essays, and podcasts, attempting to garner sympathy and credibility while vilifying her former partner. They keep mentioning podcasts where she talks about this. I don't know of any. I mean, there was like the one that like her and Gingras were doing. Is that what they're referring to? Because we had to skip, a few years. So has she ever done an interview with anybody? I just wonder. I didn't see any, but then again, they could have been taken down by now. I probably would have. I'd have been like, oh, yeah, nope, no thanks. Don't need those views. A collapse of the fraud. Over time, her fabrications unraveled under scrutiny. Independent courts and law enforcement eventually found her claims to be baseless, leading to dismissals, finding of fraud, and most recently, a felony indictment for perjury, forgery, and fraudulent schemes. That's true. Even the police were like, there is nothing here for domestic violence. Case closed. It was impossible for Marraccini to have understood at the time that he was dealing with a serial fraud. Ooh, I love that we called her that. I love it. Bacon Boots. I can't remember the name, but she was on a guy's podcast. He took it down when contact. Okay. See, I figured there might have been a few of those, which, I mean, I get it. I'm assuming this was like in regards to early Clayton days, like when she went public right away with it or something. Is that what it was? Okay. Corroboration that Laura Owens is a criminal. I love that. Owens pursued a paternity claim in Arizona against a public figure, a former reality TV bachelor, claiming she was pregnant with his twins, only to have those claims exposed as elaborate fabrications. The Arizona judge, after a full evidentiary hearing, found Owens' testimony to be wholly not credible, describing her claim as unreasonable and without basis or merit. Oh, it was about Mike, and it was a few years old. Okay. Yeah, she did have that one podcast with her mom, Nobody Told Me, which I've said before, if all of this stuff happened to you, and particularly during Clayton's time when you had this podcast, because you're a boss babe podcaster, why wouldn't you talk about all of this on your podcast? I mean, other people are besmirching your name on the internet, and here you have a whole ass platform to talk about your side of the story where you control the narrative, and yet they never did. I think that is very interesting indeed, because who wouldn't? I would. Nobody told me you need listeners for a podcast to succeed. Well, I mean, I guess there's that. Who cares, right? Oh my gosh. Nobody was recording. Nobody told me during the Clayton saga. Yeah, I wonder why. I don't know. That just seems very interesting to me. Almost as if they didn't want to see things that could be used against them in court later. Interesting. Now, the court noted that Owens had presented a false claim and falsified evidence and accused her of wasting the court's time with her lies. In fact, the Arizona judge was so alarmed by Owens' conduct that she referred the matter to prosecutors, observing that Owens appeared to have a pattern of similar fraudulent behavior in court. A grand jury thereafter indicted Owens on 7 felony counts. The indictment charges Owens with fraudulent schemes, forgery, 4 counts of perjury, and tampering with physical evidence. Investigators found that Owens went to extreme lengths to manipulate the legal process. She allegedly altered ultrasound images, fabricated a pregnancy video, and lied repeatedly under oath in the Arizona case. These are not mere allegations by Marraccini. They are findings and charges by courts and law enforcement authorities, demonstrating Owens' propensity to lie to courts and manufacture evidence to achieve her ends. Now, when we first started our coverage of Laura Owens, I think it was January, is when the investigative report regarding the charges for Clayton here, the 7 that they keep talking about, we read that first, and it was wowzers. We're probably going to reread it again now because we didn't really know much. We were like very naive little babies when we covered that. So we'll probably go over it again now that we have all of this knowledge and lore. And I can't wait to just pick up on things that we missed during that time. So, oh, the podcast is still up. It's called The Call. Oh, interesting. My sound is cutting in and out? Like bad? I don't know what to do about that. Why? Everybody's messaging me. Okay. All right. Well, don't worry. We're almost done. I mean, so. Maybe it's my hair. Sometimes my hair makes it weird. Corroboration of Owens' fraudulent conduct constitutes extrinsic fraud. Marraccini's discovery of Owens' fraudulent conduct and subsequent legal proceedings constitutes extrinsic fraud. California courts have consistently held that extrinsic fraud justifies equitable relief from a judgment or order even after the expiration of the 6-month period. Here, Owens' pattern of deceit, as documented in the Arizona court findings and her subsequent indictment, demonstrates that she engaged in a scheme to manipulate the legal system and fabricate allegations against Marraccini. This conduct prevented Marraccini from fully litigating the 2018 DVRO, as he had no way of knowing Owens' misconduct amounted to a fraudulent scheme to harass and stalk him for the duration of the order, or that she would continue this conduct indefinitely. This was bigger than the mischaracterization of photographs, he said, she said, and a little minor perjury. Just a little minor perjury. It's fine. It's fine. Okay. Little minor perjury. This was the concealment of a full-on fraudulent artifice, ripe with false medical evidence, false communications, a concerted emotional harassment manipulation campaign, and a concerted effort to ruin Marraccini's life. That is very true. That is what I took away from all of it. Under California's 3-part test, Marraccini must show 1, a meritorious defense, 2, a satisfactory excuse for not presenting a defense in the first place, and 3, diligence in seeking to set aside the judgment once discovered. So 1, the meritorious defense. To satisfy this element, the movement must demonstrate facts indicating that a different result would have been reached if the case had been defended. Oh, check that box. Agreed. For example, in this one case, the defendant showed a meritorious defense by declaring she did not knowingly allow drug trafficking on her property. Okay. Similarly, in another case, DNA evidence was cited as potentially satisfying the meritorious defense requirement if accurate. Okay. Marraccini's defense is that Owens' abuse allegations were false, fabricated from whole cloth. Substantial new evidence now confirms that Owens is a serial liar who weaponizes false allegations, positioning herself as a victim to torment men who have no interest in dating her because she's fucking crazy pants. Had Marraccini been able to present new evidence of Owens' fraudulent scheme, such as the criminal indictment and findings by other courts that anything Owens claims cannot be trusted, including Judge Mata's findings, it is highly probable that no reasonable court could have issued the DVRO. The evidence suggests that the likelihood of a different outcome was significantly high. If the court had the opportunity to learn the full meritorious scope of Owens' claims, there would have been a different result, satisfying the meritorious defense requirements. 2, valid excuse for not presenting the defense. The movement must provide a satisfactory explanation for failing to present a defense in the original action. Basically, okay, Your Honor, Mike, not a time traveler. Wouldn't have known about half this stuff because it happened after the fact, and it just turns out he is not a time traveler, unlike Greg the Hacker, who she plays for some of this evidence, some of the Mike's evidence, she blames Greg for it. It's like, Greg didn't even know who the fuck you are. Like, what? It's crazy. Oh, it's a different podcast. Okay, well, thank you for that. Oh, that coffee's delicious. Extrinsic fraud typically exists where a party is deprived of his opportunity to present his claim or defense to the court, keep in ignorance of the true facts, or in some other manner fraudulently prevented from fully participating in the proceeding. That is exactly what occurred here. Owens' fraudulent conduct prevented a fair advisory hearing by inducing the court to decide the case on false information. Now, through perjured testimony and fabricated corroborating evidence, Owens misled the court and thwarted Marraccini's ability to challenge her claims at the evidentiary hearing. Marraccini had no way to expose Owens' lies at the time. The falsity of her testimony only came to light years later. Thus, unlike a mere case of intrinsic fraud, perjury that could have been exposed at trial, Owens' actions amounted to extrinsic fraud because they fraudulently prevented Marraccini from fully participating in proceeding. In essence, Owens' scheme robbed Marraccini of any meaningful chance to present his defense, which is precisely the kind of injustice California courts will not tolerate. But he had his laptop at the time. So couldn't he have done the digital I mean, I know it was a lot of money, and he did not have a lot of money at the time, but I don't know. Okay. All right. But then again, who would assume that that doctor shit was fake? Probably not the courts, that's for sure. Plus, Mike did date her for like a year and a half. So compared to the other two, I'm sure it would have been harder, had more stuff to even go through because of how long their relationship was compared to the other two guys, which we know was drawn out for years. So, diligence in seeking relief. The movement must act promptly upon discovering the fraud or mistake, which they have. We're just going to skip that part. Marraccini satisfies the standard. The record shows that Owens' fraud remained well concealed until recently. Okay, yeah, that's true. It was only through later developments, including documentation of her perjury and falsified evidence, that Marraccini discovered the depth of Owens' deception. Okay, yeah, I could see him too, just being like, why would you think that? He didn't know that the doctor notes and prescriptions were fake. Yeah, because who would do that? Laura Owens would do that. That's who did done that. She did done that. Let's see. Marraccini did not sleep on his rights after this discovery. To the contrary, he acted with appropriate diligence. On May 25th, 2025, Owens was indicted on the 7 felony counts. July 10th, 2025, Owens filed a request to renew the DVRO. September 11th, which is the date of this filing we're reading, Marraccini responds by filing this motion. Through these actions, Marraccini has demonstrated reasonable diligence in seeking relief after discovering Owens' fraud. There has been no prejudice to Owens in the timing, as she sought renewal of the 2018 DVRO prior to this filing in July 2025. This was after her criminal indictment in May of 2025. Marraccini brings this motion a little over a month after Owens' request to renew and after he has substantially replied to Owens' allegations and after a new investigation into the layers of deceit that he suffered now for nearly a decade. God, poor guy. Owens' fraudulent conduct undermines the legitimacy of the DVRO. Relief is right here. To leave the 2018 DVRO is to bless a fraud on the court. The order was intended to protect genuine victims, not to arm a liar. Owens used it to sell her false story of being a survivor, and that lie stains the law and weakens faith in it. The courts have stated that they will not allow their orders to be used as tools of deceit. When fraud wins an order, the court has the power to strip it away. There is now strong evidence that Owens won the DVRO on a lie. The order was made without any finding of abuse. Her deceit is plain. To maintain the order would be to perpetuate the fraud. It would allow her to use the court's seal to pose as a victim, to tarnish Marraccini's name, and to twist the truth. The courts of California have the power to stop this. In a certain case, the court stated that equity may strike a judgment when the need for justice outweighs the pull of finality. And this is such a case. In Marriage Park, the court said fraud that keeps a man from a fair hearing is enough to open a closed case. Finality does not save a lie. Owens used the DVRO to dress her falsehoods in law. That abuse tips the scales. The court must guard the truth of its orders. That weighs far more than Owens' thin claim to an order won by fraud. Relief here serves the purpose of the law. The DVPA, which is the Domestic Violence Protection Act, was made to, I think it's protection, pretty sure, was made to protect the truth. It was made so the courts could believe those in need. When Owens lied, she broke that trust. She hurt Marraccini, and she hurt real victims who come in fear and in honesty. To strike the order is to say the law is for protection, not revenge or vanity. Ooh, I like that. Good job, Omar. To leave it is to reward her lies and punish a man who did no wrong. And that cannot stand. Bravo, bravo. 4, relief is necessary to prevent further misuse of the DVRO. The 2018 order must be struck. If it stands, Owens will continue to use it to harm Marraccini and possibly others. To leave it is to reward her lies. It would give her leave to twist the courts again. The Arizona court saw it, her pattern of false claims. Marraccini was likely one of the first, and the law cannot be bent to serve such deceit. For Marraccini, the order still cuts deep. A DVR carries weight and serious indeed. It brands a man. It follows him professionally in his right to hold a gun in his name. Each time he has to fly, TSA pulls him aside. They take him to a small room. They question him, sometimes for hours. They treat him as if he were a criminal. Yet, no court has ever found he did wrong. Justice calls for Marraccini's name to be cleared. The order was born of fraud. Lifting it now harms no one. The relationship ended long ago. Marraccini lives in California. Owens went to Arizona. She chased other lawsuits. She ran her fraudulent scheme on others. Whatever need she claimed in 2018 was never real. There was no cause then, and there is none now. Marraccini has moved on. He has a wife, 2 children, and a life of his own. It is a life Owens wanted, but could never have. Mm-hmm. She should not matter to him now. She should be nothing. Oh, yikes. Yikes. She should be nothing. A sour memory fading in the sun of what he has built. I bet that pissed her off so much. The court holds the chance to end this, to strike down the wrong, to guard others from the reach of Owens and her predatory ways. Things love this for her, right? Oh, I love it. I mean, Oscar. I just go, oh my gosh, not Oscar. Omar. In fairness, I've been off for a week. Okay, words are hard. He's not as snarky as Woodnick, but he is in like also the best ways. It's just like a little simple enough. Like, I know this bee is going to read it, and I'm just going to put that in there because I know she's going to hate it. I do love the salty after dark lawyer. Yes, Yes, he does it with some finesse. But in fairness, like Winnick had already been dealing with this bee for years, and she accused him of some heinous shit. So the fact that he would get real petty in the things he would file, I don't blame him at all. Real snarky and petty, especially when you're dealing with Chingris and all of that. But I should say Omar's sassiness is just, it's very smooth in there. You don't see it coming until it does. And you're like, oh, okay. Bravo. Lobster claws for Omar. 5. Sanctions are awarded under Family Code 271. Respondent seeks a sanction award of the entirety of Mike's legal fees pursuant to Family Code 271 for the attorney fees and costs incurred due to Laura's conduct in this litigation. This filing serves as a notice that Marraccini will pursue sanctions based on Laura's misuse of the DVR process, her fraudulent claims, and the unnecessary legal expenses her conduct has caused. By including this notice in the present motion, Marraccini satisfies the statute's procedural requirement and ensures Laura has a fair opportunity to address the sanctions request. Marraccini submits that the court may rule on sanctions with the motion to vacate or, alternatively, defer the determination to a later hearing after the DVRO is resolved, with this filing preserved as timely notice of Marraccini's intent to seek relief. So, like, it may come up later, but we're just going to let you know we're going to be looking for some sanctions here. Marraccini further seeks sanctions under Family Code, whatever, in light of Laura's conduct, which can be accurately described as a litigation ambush. Oh, yes, that is true. Laura's actions in obtaining and litigating the domestic violence restraining order have flagrantly violated the Family Code's policy favoring cooperation and settlement. This litigation ambush is characterized by Laura's fraudulent and misleading behavior, marking a deliberate attack on judicial resources and fairness. So let's see why she should pay them money. Fraudulent procured the DVRO. Laura obtained the restraining order through false and or misleading representations, effectively perpetrating a fraud on the court during this ambush. She also misled the court and abused the DVRO process. Laura presented misleading evidence and admitted testimony to maintain the DVRO, further amplifying the ambush strategy that undermines the integrity of these proceedings. This misuse echoes the core purpose of Family Code 271, which penalizes tactics that price parties out of justice and discourage cooperation, emphasizing the need for fair proceedings. Forced unnecessary fees in litigation. By pursuing an unwanted DVRO, Laura has turned this ambush into a costly affair, compelling Mike Marraccini to incur substantial attorney fees and costs to defend against the order and now to seek its dismissal. And here we are doing a fundraiser for him on Saturday because it's still happening. This misconduct has escalated the conflict, prevented early settlement, and imposed unnecessary litigation expenses on Marraccini. Such conduct is exactly what this family code is meant to deter. Section 271 allows the court to award attorney's fees and costs as a sanction based on conduct that furthers or frustrates the law's policy to promote settlement and reduce litigation costs by encouraging cooperation. The statute's purpose is not simply fee shifting, but to punish bad behavior and encourage cooperation in family law cases. Here, Laura's bad faith tactics, executed under the guise of a litigation ambush, have clearly frustrated the policy of the law by undermining settlement and increasing cost, triggering 271's applicability. Don Omar basically calls her sour milk. She is. Sanctions must be scaled to the payer's ability to pay and must consider the financial circumstances of both parties. Blah, blah, blah. This court has a duty and the authority to impose sanctions for conduct that frustrates settlement or increases litigation cost. However, it is important to note that 271 does not require the conduct to rise to the level of bad faith or frivolousness, as is required under other statutes. Instead, it focuses on whether the conduct frustrates the policy of promoting settlement and reducing litigation costs. California courts have consistently imposed monetary sanctions under 271 and its predecessor statutes in response to similar bad faith litigation tactics and abuse of the judicial process. All right, so for instance, in this other case, the Court of Appeal upheld sanctions against the party who pursued a bogus spousal abuse claim. A spouse's deliberate delaying tactics and bad faith conduct during divorce proceedings justified a $15,000 attorney's fee award as a sanction. Rehem- rehens- Reprehensible conduct falling short of bad faith can warrant fee sanctions under the family law statutes. These authorities make clear that courts will award attorney fees as sanctions where, as here, a party has acted in bad faith or engaged in litigation abuses that thwart the policy of amicable resolution and fair dealing. We're almost done. We have one more page to go. In this case, Marraccini asserts that Laura's conduct is more serious than the examples cited above. By allegedly creating a false basis for a DVRO and requiring Marraccini to incur significant legal expenses, Laura has increased cost and utilized court resources. This is the type of delay and expense that 271 is intended to prevent. Marraccini respectfully requests that the court order Laura to pay Marraccini's reasonable attorney fees and costs resulting from this conduct based on this code. The Court of Appeal has clarified that 271 sanctions must correspond to the actual attorney's fees and costs caused by the conduct. The requested sanction seeks only those actual fees and expenses incurred due to petitioner's alleged misuse of the DVRO process. Awarding these fees and costs will compensate Marraccini and help deter future misuse of the court system. If the court does not grant sanctions immediately, the respondent requests that the court defer deciding on the 271 sanctions until after the DVR motion is resolved, thereby keeping the issue open for later hearing. Like we're not asking for it right now. Like we'll totally keep it open for however long, but we're asking for it. Waiting would let the court fully consider Laura's responsibility for Marraccini's fees after the DVRO is addressed. This would protect Marraccini's right to relief and let the court focus on the DVRO first. Still, because the clear litigation abuse and 271's focus on prompt action, Marraccini believes the sanctions awarded now is justified. If you want to give us money now, I mean, yeah, we'll take it. That'd be great. But it's not necessary. Marraccini asked the court to grant the requested fees and costs to ease the financial impact of Laura's actions and discourage similar tactics in the future. This would support the policy of encouraging cooperation and help restore fairness as intended by the Family Code. All right, so that was the end of what we have to read. I very much enjoyed reading that. I know it's a little bit more legalese than we're used to in filings. You know, like how court filings are supposed to go. This might be one of the most closely related regular motions we've read out of all of it. But well said. I love that he's like, this B ain't getting away with nothing. He called for, this to be sent to a district attorney. Now, is all that stuff going to be granted right away? No. No, but I do like that he asked for it. So, let's see what you guys are saying over here. You stole your parents' Johnny Walker Red. Ooh, girl. I don't drink whiskey. It does not like me. Is it just you or your feet cutting in and out? I don't know. It might just be you because nobody else has said anything. But then again, my chat is very nice. So they sometimes don't say things out of niceness. So that is where we are going to leave today. As I said, I will be back tomorrow at 10 a.m. Eastern. And what are we covering tomorrow? We got an ex parte application for a continuance of hearing. I'm assuming that's from Laura. Oh, we have a declaration for Laura, some many minutes. And then we'll go over the witness list and exhibit lists. And then there's a 35-page motion in limine. Oh, who's that one for? Let's see real quick. Who files that one? Oh, this is to exclude witnesses from Laura. Okay. Because of course she's going to go through. It looks like she's going to go through each witness and talk about why they should not be allowed to be witnesses. All right. So tomorrow's going to be a fun and entertaining day. Can't wait for that. As I said, Terry True Crime does Midday Missing right at 1 o'clock. Oh, it's not on your end? Okay, that's good. I'm also going to be posting some stuff under a community tab for the fundraiser. So I know we're going to be asking that if any of you have any words of support you would like to send to the Marraccinis, whether you want to write it up or you want to do a short video of support, please send those to either me or Winks, Tara at tcwtmedia.com. We want to put something together for them so that way they already know how much support comes from the community, but as I've just received so much supporting words from you guys, I can tell you that it just makes all the world of difference to hear or see someone's words of supporting you and makes you feel, less alone. So if you have anything you'd like us to pass on, please email it to me or Winks. I will, again, be posting it under a community tab, a few things. So keep an eye out on that. And then let's see. Oh, you got to figure your technology out. Oh, my goodness. So that is all I've got for you today. As I said, watch Terry True Crime Midday Missing. Those are really important. And then she also does Dearest Mothers tonight at 9 p.m. I'm not sure which case she's covering, but it'll be nice. Oh, thank you, Dawn. Dawn said it was great to be back with you. I'm so happy to be back with you guys too. Even though a lot of it's just me talking to myself on here, but no, I definitely have missed it a lot. So I miss you guys. Oh, thank you. Can't wait for all the shenanigans. Also, make sure this coming Saturday, cancel all your plans. Turn off your notifications, except for this channel. But don't accept any phone calls or anything. Be like, hey, if you want to talk to me, then you're going to need to go over to the True Crime and Wine Time YouTube page and talk to me in the chat because I am busy with a 12-hour fundraiser. So you should just tell people, if you want to talk to me, come to the chat. Other than that, I'm not going to talk to you today. Well, thank you guys again so much for being here. I'm so excited. You're going to get so much of me this week. And I appreciate you all so much. So until next time, go forth and be amazing. All right. Bye, friends.